and the Chapter 13 committee, which is a part of that commission. I would like to welcome all of you to this public hearing, which will be the only hearing that the Chapter 13 committee will hold in public, and we are so appreciative of the NACTT for allowing us to have this opportunity to conduct this meeting at your conference. Having said that, we are under some time constraints. We have only an hour and a half because this room is going to be utilized for something later this evening, so we have to leave on time. And as I told the committee members earlier, we're like Cinderella. At the appointed hour, we will be leaving the building. So we will try to stay on schedule as best we can. We have a good representation of the Chapter 13 committee here. A couple of our members were involved in other panels. I'm not sure all of them have gotten here yet, but I'm going to run through our list quickly so you'll know who is up here at this head table. John Rayo, who many of you have heard him speak earlier today and earlier in this conference. Angela Litwin. Hank Hildebrand, who is no stranger to anyone in the NACTT, nor is the next man, David Peake. Beverly Burden, Chapter 13 trustee. Jason Miller. Alan Beckett. Keith London, who spoke at length this morning with Hank. Michael Bates. Seated next to me is Bob Lawless, professor at the University of Illinois, who is our commission reporter and also the reporter for each of the committees. So we appreciate your allowing us to be here with you today, and we hope that what you hear will be of interest to you. The purpose of this is to gather input from people in the business, to let the commission hear your thoughts, hear your ideas about what we need to address. We're going to do this in a series of 3 panels, 3 people on the first 2 panels, 4 on the last panel. They're allocated 6 minutes to speak. Our timekeeper is Bob Lawless, who used to do this way back when for the 7th Circuit Court of Appeals when he was clerking for then 7th Circuit Judge Harlington Wood. So he knows how to hold up the signs to give you warning that your time is drawing nigh. At the end of each panel, not at the end of each speaker, but at the end of each panel, we will have a question and answer session and comment session, not just from members of the committee, but from members in the audience as well. There are 2 microphones there in the middle of the floor. And if you would, please come to the microphone if you have a comment, suggestion, or question to any of our panelists. So, having said all that, I will introduce our first panel who will be speaking to us. We have Steve Porosky. We have Pam Basil and Joyce Babin. Mr. Porosky, I presume that you are our leadoff hitter.
My name's Stephen Porosik. I'm from Shapiro Fishman and Gachet in Tampa, Florida. Been representing creditors for over 15 years. I want to talk about raising or eliminating the 109E debt limits in Chapter 13 because we've been having numerous problems with individual Chapter 11s being filed by consumers and utilizing the provisions of Chapter 11 for purposes which I don't believe Chapter 11 nor are my clients believe that Chapter 11 was meant to be utilized for. I'm primarily concerned with Chapter 11 cases of $5 million of secured debt and under. I represent mortgage creditors, and these cases run into numerous problems pre-confirmation and post-confirmation. So I'd just like to get into some of those, touch on the highlights that I see and that I've seen over the years, and see how Chapter 13 may be more beneficial for these debtors and for the creditors and for the court overall. First of all, in a Chapter 11, when a Chapter 11's filed, sometimes they're filed by debtors' attorneys who don't want to go to these conferences that we're at here. They're filed by debtors' attorneys who may just want to park the case in Chapter 11. They're very happy not filing plans, not moving the case along at all, not advising their clients to pay the taxes, the insurance for many, many properties, possibly. That puts the burden on the creditor to then request adequate protection for necessary and actual expenses that were incurred after the case was filed, pursuant to the In re Timbers case. That's challenge number one. Challenge number two is to actually get the cases moving towards confirmation. If we have a debtor's attorney who filed a Chapter 11 case, and their client's actually working towards a plan of Chapter 11, and we actually get to the stage where a plan is filed, we have to deal with various treatments by different judges in the state of Florida regarding the first hurdle for the disclosure statement, whereas we don't have a disclosure statement, of course, in the Chapter 13. We have to get past some judges wanting basically everything in order as if the Chapter 11 plan confirmation hearing is taking place instead of a disclosure statement hearing, whereas other judges are more lenient, and they'll allow that disclosure hearing to take place maybe on a temporary basis and then consider it finally at a Chapter 11 confirmation hearing. The problem that we run into is when, let's say that most of the time the debtors are filing a Chapter 11 to cram down non-homestead mortgages, you get to the confirmation hearing, and that's just the beginning of your problems if you're the creditor and sometimes the debtor. Gotcha. Let's say we have a confirmation, Chapter 11's filed, we get it confirmed, the debtor and the creditor agree, there's some type of cram down usually involved for many different properties. We work very hard to try to get the escrow situation addressed in the plan, but we don't have a trustee, a Chapter 13 trustee, to go and look at the records. We can figure out the effective date of the plan, but then it's up to the debtor in possession, to make those payments to our clients. We have no records. As outside counsel, we have to rely on our clients. If they come back month after confirmation and telling us that the debtor's not making the payments, we're going to look at the plan terms. Some debtors' attorneys put in default provisions in the plan terms where we email, we communicate, forced communication. Other times, they don't want to be bothered. Go to state court. One remedy, go to state court. Some U.S. trustees say, don't even come back to me post-confirmation. Another remedy is to move to dismiss the case post-confirmation. You can do that. Some judges like that, some don't. So it's just a lot of accounting errors which could go on 30, 40 years in the future. And these Chapter 11s never go away. Just because they're in Chapter 11 and they're in a confirmed case, they're not discharged yet. So, you just have the recurring problem in all these cases where it's a payment dispute again. And I don't see what the benefit is for the court system or debtors or creditors when we have those issues going on. The last thing we want to be dealing with is an escrow dispute, a pay dispute. And, I've heard it mentioned from some debtors' attorneys that they're not, they want to get these cases administratively closed after confirmation to avoid the U.S. trustee quarterly fees. So these cases sometimes look closed on the docket. That causes other problems for creditors and have to reopen the cases and pay a reopen fee. Those are some of my concerns. Thank you for the time, Commission.
Thank you, Mr. Perozik. Now we have Pam Basil, a Chapter 13 trustee from North Richland Hills, Texas.
Thank you very much. I really appreciate the opportunity to address the Commission on a few things that I put in my written testimony. Can you hear me? Barely. Barely? I'll try to speak up. Okay, that sounds a little bit better. One of the concerns that I wanted to raise is the issue of a lender who has the right to foreclose because the stay has lifted or property has been surrendered, but does not want to foreclose or delays foreclosure, and the problem that creates for the debtor. Oftentimes, and in fact, I think this is why you're starting to see some of the cases where the debtor is attempting to vest title to property in the lender because the debtor needs to transfer title. Otherwise, the debtor continues to be responsible for things like taxes, insurance, maintenance, protection of collateral that they may no longer need, may no longer be able to protect, and simply need to transfer title to it so that they can move on with their lives. And there's a lot of wholesome reasons for this. It's not always because the debtor has done something the debtor shouldn't have done. Sometimes the debtor needs to move because a job opportunity is opened up in another part of the country. Sometimes the debtor has reached the realization that they can no longer afford to pay for or protect and insure collateral, so they do need to transfer title. The problem is, under 363, it's a darn hard thing for a debtor to do because the lender must consent. If the sale of the collateral is not going to produce as much compensation or consideration as the amount of the debt that's owed. And this leaves the debtor in a very difficult position. So one of the things that we suggested, and I would like at this point to give credit to my staff attorney, Ethan Cartwright, for helping me figure out what our suggestion was going to be, and that is that the lender have a specified period of time in order to foreclose, and along with that, the right to credit bid. But we had suggested 120 days. But after that time, unless the court enters an order otherwise, the debtor would have the right to sell the collateral, and the lender would lose its right to credit bid. And that losing the right to credit bid issue is important for reasons that I'll get into in just a moment. This would not be unilateral on the debtor's part. The debtor would still have to file a motion with the bankruptcy court, give proper notice to the lender, who could come in and object. But the court's responsibility would be to determine whether the proposed sale was for fair market value. And if it is for fair market value, then the sale would be allowed to proceed. The lender would get whatever proceeds are generated, and presumably any deficiency claim the lender had would be treated as an unsecured claim in the case. The reason that I think it's important for the lender to lose its credit bid is that oftentimes, just to be frank about it, what we're talking about is a sale of the debtor's house. Most debtors need real estate brokers to help them make certain that that transaction works the way it should. Brokers are not going to want to assume the risk of doing the work, bringing a buyer to the table, only to have the lender come in and credit bid at the last moment, derail the sale, and then the broker is not compensated for their time via their commission. So I do think at some point it's important for the lender to lose the right to come in and derail the sale by utilizing their right to credit bid. So that was the first point that I wanted to raise. Other people are going to speak on this, but I do want to say that I do favor some modification of the bankruptcy code to allow the debtor to modify a lien secured only by their principal place of residence. This is the number one issue that most of our debtors face. Number two is student loans, but number one absolutely is the mortgage loan. And one of the things, or some of the things that we suggested in the written comments submitted were potentially allowing the debtor to extend the term by a specified period of time, say 5 years, 15 years. I mean, that would be something obviously would have to be discussed thoroughly. Allowing the debtor to reduce the interest rate, at least over the term of the plan. There's some other suggestions that we made in the written comments, and other people, as I know, are going to speak on this, so I would like to move on to something that I'm not sure is going to be raised by anybody else. This next point is something that I will just tell you frankly irritates me, and that is the way we calculate disposable income for an above median debtor. And the reason it irritates me is that they get a break that the below median debtor, who probably needs the break more, does not get. And this is how it happens. We utilize the official form in calculating the disposable income. That official form, most courts who have ruled on this matter say that the debtor is entitled to deduct the full IRS standard from their income in order to get to the disposable income number. And what this means is that if the IRS standard, for example, is a car, and it's $485 in the region where you happen to be, but the debtor is only paying $315 for that vehicle, many courts have said the debtor is entitled to deduct that entire $485. So you're building in a cushion, and you're depriving the unsecured creditors of that part of the cushion that could have been put into the disposable income calculation. The problem that I have with this is the below median debtor does not get that break. If the below median debtor is paying $315 for a car, that's what they get. By the way, my time is up, but I also believe we ought to work in a cushion for all debtors, not just above median debtors.
Thank you, Ms. Basil. Next speaker is Joyce Baden, Chapter 13 trustee from Little Rock, Arkansas. And I will understand her accent.
Thank you for the opportunity to speak today to the panel, and thank you also for holding this hearing at the National Association of Chapter 13 and Trustees Annual Seminar. I currently have the privilege to serve as president of the National Association of Chapter 13 Trustees, and I know this organization, the trustees involved, are very appreciative of the topics that are being studied by the ABI Commission on Consumer Bankruptcy, and appreciate the efforts made by all the parties. I've had an opportunity to review the topics of which you're reviewing, and obviously not that you need to hear that from me, but from my colleagues that have expressed opinions. We think that you all have targeted issues that are of concern for practitioners in all aspects, from debtors, creditors, trustees, and even courts. As president of the NACTT, I want to just highlight some of the efforts, because I do believe that trustees, Chapter 13 trustees in particular, have been on the forefront of leading issues for consumer bankruptcy reform for its 52 years of existence. Some of the opportunities that we have taken is we have promoted debtor education before that became a requirement of the BAP-CIPA in 2005. We work in various areas of best practices, from information that trustees ask from attorneys to a mortgages committee that has worked to provide a set of best practices that we can give to mortgage companies and servicers that help to provide that information, because the more communication we have in that area, the more it helps. We also have been involved in data collection so that creditors can have the opportunity to obtain data either directly from trustees or from a nationwide data center that has information. Why do I take my time to highlight these things? I think first, they're very important. Second, I want to encourage any of your members that wish to reach out to our organization for any assistance or information. We are here to do that. We are obviously always wanting to make the system better, and that is part of our goal. I have had numerous people, and I've asked around about different topics which comprise some of my written materials, but one thing that has been highlighted, and I know you will hear more than once on this panel, because I'm about to say the words debt limits. I do believe and support raising of debt limits in Chapter 13 cases. One question becomes, and it's been interesting to ask practitioners around the country, how much should the debt limits be raised? Should they be raised doubled? Should they be raised enough to become a small business or a individual small Chapter 11? I think that Mr. Steve, whose last name begins with P, raises good points. Palachek, I believe, is how he said it. I also think that, I know when we looked at the information that your committee was studying regarding student loans, you had the category student loans, and there was no outline underneath. I think that's what happens when everybody sees student loans. It becomes a head scratcher. But I think that I would urge the committee to study and make recommendations, at least to provide some relief for debtors, where if they can make payments during a plan, or some way where they can do something, even if they've incurred the debts, where they don't leave bankruptcy cases more owing more interest and owing more debt than they did when they started, because that just kicks the ball down the field and doesn't get them anywhere. I applaud that the Commission is looking at forms under their systems category, because I think that one input I continually receive is these forms are long. I think about debtors' attorneys who have to copy these forms for debtors. Even though bankruptcy court is paperless, many times when it gets to the debtor, it's not paperless, and it's expensive for the debtors' attorneys to copy all of the forms. Additionally, much has been discussed on the plan length and whether a plan should be allowed to be 60 months, longer or shorter, something like that. It's interesting, though, that as a trustee, I have to give out a notice of final cure payment. I can't give that until the last payment's been made. That's at the 60th month. So just by virtue of the rules, the plan exceeds 60 months. As long as that's something that the court is cooperative, and thus far it has been, but that's something to think about when people are talking 60 months. It's been built in for the debtors to have, you know, they run against the end of their plan before, you know, at the end of their payments, and they may still be maintaining payments while you're getting the cure or working out the cure on the arrearage. So the 60-month plan is actually always a little longer than 60 months. I appreciate the opportunity to speak, and I will yield the remainder 45 seconds of my time.
Thank you very much. I want to tell all of you that most of these panelists have submitted written materials, written comments before their oral presentation today. And I would encourage anybody in this room, if you have a suggestion or comment about an area of the law, the rules, etc., that need to be looked at in your mind, send it to us. The information on how to do that is on the ABI website, and we will definitely look at anything that you submit to us. In fact, many people that will not be speaking today have sent in written materials that have prompted several of the topics that we are now considering. So please do that. Don't let this be the end game today. You can still have an opportunity to submit something in writing to us later on. Questions from the committee to the panelists?
I have a question. Beverly Burden, Chapter 13 trustee. Ms. Babbitt, in your written materials, one of the comments you made, and this is something that the committee members have talked about, is whether conduit mortgage payments should be required or not. And I just kind of wanted to take this opportunity to poll the audience and get a show of hands. How many people feel that conduit mortgage payments through the trustee should be mandatory? Huge majority. How many people feel that debtors should have the opportunity to make mortgage payments directly, whether they're current or not? So quite a few people. What if they are behind in their mortgage payment? Should they have should they be required to make conduit payments if they come in and they're behind? Okay, thank you.
Next, from the committee. Any comments from the committee? Questions or comments from the floor, please? Excuse me, I'm sorry.
This is Jason Miller.
I'm sorry, Jason, I
No problem.
didn't see you.
In-house counsel with Santander. Ms. Basil, you raised, excuse me, a concern about vesting in so much, about the creditor should have the obligation, but should in so much take their property back. I assume it's going to be a surrender, correct? Or the debtor's going to make some effort to turn that property back over?
Absolutely. I think my concern is I don't think any lender should have to take title to anything they don't want to take title to. I mean, you didn't have title to begin with, and you might not want title now. But the debtor needs a way to transfer title away from themselves. And if they are selling the property for fair market value, which would be a determination made by the court after due process to the lender, there has to be some way for the debtor to divest themselves of title. Okay. And that's why I don't like the solution of saying you can vest it in the lender. The lender may, for many very legitimate reasons, not want title to that piece of collateral.
Thank you very much. I just want clarification on that because I believe the majority view right now is, as you pointed out, the creditor doesn't have to take it back. So, but I definitely understand the concerns. Thank you very much.
May I follow up on that question, please?
Mr. Burks, go ahead.
So, if you start messing with vesting, don't you have to take into consideration each state law's property rights? You can't vest or non-vest or force a vesting or condition a vesting or set conditions upon vesting contrary to state court rights. I mean, that's not what bankruptcy does. So I'm not sure I understand where the conversation is going, but if it goes somewhere, we should be thinking about what state court rights the lenders have and the borrowers have, and I don't think we can change that in bankruptcy law.
And I think you're absolutely correct, and that's one of the tasks that a subcommittee is going to have to look into. I'd love to say it's my committee, but it is not.
Well, thank you for y'all's committee consideration.
Spoken well from a guy from Houston, Texas, who used to practice before me when I sat out there as a visiting judge for a number of years. And that y'all resonates with me too. Anyone else from the floor that would like to offer a comment? All right, well then thank our panel for our first panel for your comments and your suggestions and your input. It's exactly what we're looking for. Thank you so much. I would ask our second panel to take your places. All right, in the order that I have them, our second panel will be Nancy Whaley, Chapter 12 and Chapter 13 trustee from Atlanta, Rhonda Winnicor, Chapter 13 trustee from Pittsburgh, and Corrine Flores from the American Payroll Association, Washington, D.C. Ms. Whaley, the floor is yours.
Commissioners and committee members, thank you for the opportunity to be heard this afternoon. I want to start off by quickly just making a thought to the committee, and that is that the benefits of Chapter 13. And I really encourage the Commission to start with the premise that Chapter 13 is a viable option for people in need of financial reorganization. And while improvements in the process can be made, I believe that the basic structure and premise of Chapter 13 works. And I urge this because I believe that your inherent beliefs in Chapter 13 directs one's outcome. And if we start with a positive, that we want to improve the system, then I think we end up at a better place. And I look at what Congress had an inherent belief that we had a ton of abuse in consumer, and we ended up with BAP-CPA. And so I hope that the positives of Chapter 13 is what drives the Commission. I'm going to address three topics on eligibility. One is to eliminate the pre-petition budget and credit counseling requirement under 11 U.S.C. 109 and 521. While this requirement, I believe, was implemented for good policy reasons, the reality of it is it has become a bureaucratic step to the filing and no real benefit to a debtor. It's an additional cost to filing, and it creates unnecessary litigation when the debtor does not obtain the credit counseling within the requirements of the code. I've been told that the average time of a credit counseling session is about 8 to 12 minutes. And these sessions, as we all know, are taking place in the lawyer's office after it's been determined that the debtor needs to file Chapter 13 or Chapter 7, and so it's a step for them to file, not necessarily a means of trying to find an alternative to bankruptcy. Even with the higher income debtors, the counseling sessions do not appear to produce the required budget or plan of action. And while the financial management courses that debtors are required to take before the discharge have strong, substantial content, and I believe provide a lasting benefit to debtors, there does not seem to be any real lasting or any effective benefit from the credit counseling. The second, which has already been mentioned twice, would be to either increase or eliminate the debt limits under 11 U.S.C. 109E. Increasing the debt limits for Chapter 13 will give greater access to justice for individuals that currently exceed the debt limit in Chapter 13 but cannot afford the time or the money of a Chapter 11. As a Chapter 12 trustee, I see firsthand the benefits of a higher debt limit. If farmers were constrained by the limits of Chapter 13, Chapter 12 would not be a viable option for most of them. And I believe in today's society, as home prices vary throughout the United States, and consumers living in high cost of living areas, they're banned from filing a Chapter 13 because of a high mortgage debt. Also, the debt limits in Chapter 13 prevent a lot of DBAs and professionals, such as dentists and doctors, from filing a Chapter 13. And while these cases are not complex or need the various provisions of Chapter 11, they end up not being able to file at all, or they file in a very expensive Chapter 11. And I believe that these cases would benefit from a chapter in which there is a trustee and the expediency of a Chapter 13. Last, I would like to see the committee review the possibility of creating a ban on bad faith filers or abusive filers by amending 11 U.S.C. sections 109G and 1307. The current statute does not directly provide a dismissal of a case with a ban on refiling for bad faith filers. Courts currently use 11 U.S.C. 105 and 109G. However, neither one of these are direct, and they're not without challenge. Amending 1307 to provide courts with a dismissal that bars a debtor from refiling after finding of an abuse of filing in a current case would provide trustees and creditors a clear remedy to seek. It would give the opportunity for the courts, it would give a statutory authority to the courts to dismiss a case with a ban on refiling without taking away the discretion of a judge. The benefit would be to prevent abusive filings that take up the court's time and trustees' time and resources, and it would also give creditors a clear path of a course of action after the case has been dismissed. I thank you for your time and look forward to any questions.
Thank you very much. Ms. Winnicor, Chapter 13 trustee from Pittsburgh.
Thank you, Judge Houston, and to the members of the Consumer Bankruptcy Commission. I thank you, and I am grateful for your attention to consumer bankruptcy issues. I have been a Chapter 13 trustee and a member of ABI for 17 years, although my pre-trustee background was not in bankruptcy, so I'm still a newbie in that regard. I'm concerned that the players within the bankruptcy system have lost sight of its most important and largest constituency. We are so compartmentalized that debtors, particularly consumer debtors, pay for most of the bankruptcy system, but have little place or voice in the system that we serve. I don't presume to speak for debtors, but I have administered tens of thousands of Chapter 13 cases and have a wish list of changes, many of which will require legislation, that I believe will improve the Chapter 13 experience for those who need it most, the people we serve. The first is to echo my colleagues. Eliminate the unjustifiable protection from modification of first home mortgages in a Chapter 13 case. Chapter 12 provides the model. It works. It works well for 12 debtors, and it's about time the mortgage industry actually came to the table and agreed that we need to fix this. We can't keep fighting it. The cost of fighting it has to be significantly more than fixing it. I would also echo Joyce Babin's remarks about the contributions of the members of this association, and one of the main areas that we have been active in and proactive in is mortgage litigation. We are concerned, we have worked from the 2008 crisis on with the mortgage lenders to establish a closer working relationship and to try to resolve many matters that otherwise would have resulted in costly litigation on both ends. I echo all of my colleagues in asking you to approach legislation that will expand the debt limits significantly, or, as Nancy Whaley said, eliminate them entirely. Chapter 13 offers a cost-effective and efficient alternative for sole proprietors and self-employed individuals to reorganize their businesses and finances. For many, the debt limits preclude access to Chapter 13 and force individual Chapter 11s, which are far more expensive and far more likely to fail. Allow discharge or partial discharge of student loan debt. And yes, it's going to require some pictures, and it's different for those which are private from those which are government, but we need to take a picture at these look at these loans. Overturn Harris versus Vigeland. It is a simple matter of time before a trustee, in the middle of a distribution, sends funds to creditors unaware that the case has been converted. The funds that the debtor pays in should go to creditors and debtors' counsel. Overturn Midland Funding versus Johnson. It makes absolutely no sense that a debtor can be compelled to pay a stale claim in bankruptcy, but not be obligated to do so outside of bankruptcy. Johnson imposes additional duties on Chapter 13 trustees for where no legitimate bankruptcy purpose would be served. Amend RESPA. And I admit I have a personal gripe here. To clearly delineate the Chapter 13 trustee as an authorized person for the purpose of asserting notices of error or requesting loan information from mortgage servicers. Require all mortgage lenders to maintain loan histories in a consistent, comprehensible format, both in and out of bankruptcy. And yes, I believe that all trustees should be conduit, because I think the picture for Chapter 13 debtors is clearer when the trustee hands over a paid ledger to the mortgage creditor. And I also think it enables us to have the resources to support debtors who otherwise be able to fight this battle. Repeal Section 3062C. You know that relief from stay on the second round, it doesn't work. And it just makes work for everyone, costly work. Debtors' counsel fees in dismissed and converted cases should be non-dischargeable. Repeal the means test in Chapter 13 cases. All debtors should calculate disposable income as actual income less reasonable and necessary expenses. Amend Section 1326C to create a presumption that all payments are made by the trustee absent clear and convincing evidence to the contrary. Legislatively adopt the decision of the Third Circuit Court of Appeals in Shovelin versus Class to allow the debtor to complete a Chapter 13 plan that has extended more than 60 months. Again, I realize that most of this list requires legislative fixes, but if we don't ask, it won't ever happen. Thank you.
Thank you. Our next panelist is Corrine Flores, American Payroll Association.
Thank you and good afternoon. Today I'm here to represent the American Payroll Association and to share with you the voice of the employer. The APA, American Payroll Association, appreciates the opportunity to participate in this meeting. We're committed to sharing our knowledge about the role the payroll professional shares in the context of the Commission's mission to recommend improvements to the consumer bankruptcy system. APA is a nonprofit professional association serving the interests of payroll professionals in the United States. Today, we have more than 20,000 members. Our primary mission is to educate members and the payroll industry about the best practices associated with all the applicable federal, state, and local laws. In turn, we recommend improvements to minimize the administrative burden on employers, individual workers, and government bodies. APA's Subcommittee on Child Support and Other Garnishments is interested in the Commission on Consumer Bankruptcy Committee because our members process bankruptcy deduction orders and send payments to trustees on behalf of our employees that have sought Chapter 13 bankruptcy protection. We offer two primary recommendations for consideration. The first being implementation of an electronic delivery for bankruptcy wage deduction orders and electronic transfer of payments to the trustees as a best practice. Second, creating a standardized wage deduction order across the states. APA encourages the development and implementation of electronic capabilities for employers' receipt of the wage deduction orders and payments to trustees, given an imperative to keep administrative costs low for employers and to carefully track the debtor's plan. It seems essential that bankruptcy transactions move to an electronic process. Where paper is necessary, for very small employers or trustees, the bankruptcy system should enable the option for electronic fill-in forms or, at a minimum, two-dimensional barcodes for any paper submission process. This has worked very efficiently for the child support orders that employers receive today. All states have implemented the electronic process for sending child support orders. A standardized file format would also be beneficial to ensure the data elements are consistent amongst the states and trustees. Ideally, bankruptcy wage deduction orders and payments should be processed through a centralized location if at all possible. This includes electronic funds transfers such as third-party payment created by the National Association of Clearinghouse. We also recommend there is a standard bankruptcy payroll wage deduction order. APA recommends that that standard order help employers help their employees. The standardized bankruptcy deduction order should include, at a minimum, a standardized form name, standardized data elements, standard information for the trustee, as well as email addresses and court information. Additionally, having at least the basic information from the employee to include the full or the last four of the Social Security number. Large employers consistently have employees that have the same name. Additionally, there's also basic data elements that we need in order to process the payment successfully. So in conclusion, APA supports a bankruptcy system that offers standardization, effective and efficient methods to allow us to process these wage deduction orders on behalf of our employees. Employers are processing thousands of various types of orders coming in the door for child support, bankruptcy, student loans, and other varieties. Electronic and standardization helps us to help the programs be successful. Thank you.
Thank you, panelists. Questions, comments from the committee? Hank?
I've got a couple of questions.
Ms. Whaley, you suggested that the method by which we could deal with the abusive refiling was in 109G. Do you think that the 362 C3 and 4 is just a failure they should be gotten rid of, or do they serve a purpose? And you said the court should have the discretion, are we making that now subjective instead of objective?
The problem, can you hear me? Is this working? Yeah. The problem that we have had is that, and the reason I said 109G is because I think it ends, if a case is dismissed with a bar of refiling, then it becomes an eligibility issue under 109G in the future case. That's why I referenced 109G. I think 1307 is where we could put a dismissal provision in 13 that would allow a judge to, when an abuse has been found, to bar a debtor from refiling a case for a certain period of time. The problem that we have had is that many times we have creditors contact us and think that 109G has been invoked because a debtor's case has been dismissed for failure to properly prosecute the case, while it's just a standard order of dismissal. There is no bar to refiling. There is no action. So many times, I don't know what people are seeing throughout the country, but we see orders dismissed with prejudice. There's nothing in the code that references a case being dismissed with prejudice. There is nothing that when we have an abusive case and we take it and we ask for a bar of 6 months, 12 months, 18 months, 2 years, 5 years, whatever the degree of severity, the court seems to feel like 105 is their only mechanism of acting in those type of cases.
Anything else?
Well, if nobody else does, I've got another one. This is to Ms. Winnicor. You mentioned, as you were going through, that attorney's fees on dismissed or converted cases should not be subject to discharge. Could you expound on that?
I think they need to, ideally, you should be able to pay them as the 13 trustee prior to dismissing the case on your system. But at a minimum, they should follow the debtor out of the bankruptcy.
So I'm asking because if a debtor fails to make payments, you file a motion to dismiss, and the case is dismissed, the debtor's attorney just sues the debtor because they didn't get a discharge. But in a case in which the case is converted to a Chapter 7, you're saying that survives the Chapter 7?
Yes.
Mr. Rayal?
Ms. Flores, Your recommendation for a bankruptcy deduction order, am I correct that you would like there to be either an official form, a bankruptcy form, or a director's form for that? And has your organization ever made a request for that from the Bankruptcy Rules Committee?
So yes, we would like a standardized form, and we have not made a request for that, but that is a very good suggestion, so we'll be taking that back. But that is something we would like to see, because we do see trustees send a variety of cover sheets over to us, and so it's really us having to interpret that and sometimes get our legal counsel involved as well.
Other comments or questions from the committee? From the floor? Anybody have a comment about, okay, Mr. Burks?
Thank you, Mr. Chairman. Regarding dismissal, I don't know what the committee's thought is on Section 349A, but I thought that judges around the country had wide discretion to dismiss a case with prejudice for cause. And so if the committee's going to take this approach, that is, maybe put a rule in effect, I think it would be a procedural rule, not only with respect to 105 or 109G, but also with respect to 349A, because I believe courts have wide discretion to do what the speaker was referring to. And that's just a comment for the record. Thank you.
Thank you. Anyone else from the floor? Well, let me say that the commission will be looking at various avenues of how to make these changes that we ultimately come up with, whether it be legislative changes, rule changes, local rule changes, or a suggestion that previous decisions ought to be reconsidered. But we're not going to back away from any topic simply because it might require legislative action. And I realize that that's a tough hill to climb, but we're going to put it out there, maybe not for it to be climbed next week, but perhaps sometime. So that's the thought process of the commission on where we're going. Okay, no other comments or questions from the floor of this panel. I thank you very much for your participation. I used to always say this in court, we're playing your song. All right, our next and last panel, and many of these have also submitted written materials. Deb Miller, Chapter 13 trustee from Fort Wayne, Indiana. John Crane, who chairs the NACTT Mortgage Committee from Duluth, Georgia, and the firm of RAS Crane, LLC. We have Mark Bonney, Chapter 13 trustee from Muskogee, Oklahoma. And then finally, Andrew Jimenez, a staff attorney for the Chapter 13 trustee in San Juan, Puerto Rico. So, Ms. Miller, we will start with you.
Thank you for inviting me today and allowing me to speak. My name's Debra Miller. I've served as a Chapter 13 trustee for Northern District of Indiana, Fort Wayne and South Bend divisions for the past 17 years. I'd like to talk today on 3 issues. And I'm trying to give you a bit of a human face on perhaps the student loan issue that you're not aware of. Unlike most of you, law school was a second career for me. I actually started law school in 1993, finishing in 1996. And during that time, I took out a total of $40,000 of student loans for my tuition and books. Upon graduation, the only job that I could find was to clerk for a state court judge for 2 years. And during that time, I had to defer my student loans because I had a 4-year-old and 6-year-old at home. I became an associate for a law firm for 3 years and then was fortunate enough to become a Chapter 13 trustee in 2000. However, I was not a max comp trustee. I was a startup trustee, which means I took no income at all for the first 2 years, basically no income for the first 2 years as trustee. So I deferred my student loans another 2 years. By the time that I began paying my student loans in 2002, I owed $69,000 on my student loans, $29,000 more than I had originally taken out. I would note that I have never defaulted on my loans. I have only paid a total of $360 on my late fees on my student loans. Why do I bring this up? Because as of today, I have paid over $112,000 on my student loans. And what is my balance? We had a dance last month because as of my payment last month, my student loan balance is back to the amount that I originally took out of $40,000. Now you ask, how can this be? Well, unlike student loans, unlike mortgages and other loans, and I'm sorry, I'm really nervous, student loan providers can capitalize any interest due, and by the end of the 60 deferral, that interest that was capitalized was the $69,000. I'm very blessed and I'm very fortunate. I have a wonderful job. I've been able to pay the ongoing monthly payment every month, and I've made every payment and done everything that I'm supposed to. Yet 21 years after I graduated, I still owe the full amount of student loans that I took out to go to law school. The allowance of student loan providers to capitalize the interest, which requires the borrower to pay interest on interest, and the statutory and case law in this area, which allows student loans not to be subject to the same provisions as the IRS and other taxing authorities as to the application of payments, the payment of post-petition fees and costs, and the collection costs, keeps any debtor who has student loans from obtaining a fresh start. This needs to be changed. At a minimum, student loans should be subject to the same provisions and requirements of the Bankruptcy Code as any other government-backed claims. Additionally, I would ask that the Commission work with Congress and Senate to revise the regulation and statutes, to rein in the student loan servicers, to allow relief to the borrowers and to the co-signers and the borrowers of the parent loans through the bankruptcy court process. In the interim, I think that allowing debtors to pay student loans as a long-term debt under 1322B can provide more immediate relief to the debtors until the long process of changing the statute of rules could occur. The second thing that I'd like to bring up is that there are substantial issues with the way that ongoing residential mortgages are serviced while a debtor is in a Chapter 13. Some servicers fail to comply with the terms of a confirmed mortgage and the provisions of the Bankruptcy Code by applying payments in a proper manner consistent with the requirements of the confirmed plan in the Bankruptcy Code. Servicers fail to properly analyze escrow accounts yearly as required by RESPA, fail to comply with the Bankruptcy Rule 3002.1 in filing payment changes and fees assessed to the account. Additionally, when a trustee brings up these issues or seeks to hold servicers accountable or verify that trustee payments are being properly applied, we face questions from the servicers as to the right of the conduit trustee to do so, as well as questions as to standing or whether or not we're an agent under RESPA, Reg X, or TILA. But what is most disturbing is that the debtors are still failing to receive their fresh start due to some of the servicers' actions in a Chapter 13. This undermines the whole systemic integrity of our system and can nullify the sole reason that the debtor chose to file bankruptcy, to save their house, by the late notice charges or in some cases foreclosures filed within months or days of a debtor receiving their discharge. I thank you all for your time and your willingness to serve on this important commission and committee, and I wish you well, because Chapter 13 is a wonderful process, and I believe it can be further expanded to help even more people. Thank you.
Ms. Miller, thank you for personalizing a very difficult issue. I appreciate your comments. John Crane, the co-chair of the Nactt Mortgage Committee. Mr. Crane.
Good afternoon, Commissioners. My name is John Crane. I'm from the law firm of Raz Crane in Atlanta, Georgia. But as you pointed out, I'm here today in connection with my role as the co-chair of the Nactt Mortgage Committee. I'm going to bring up 4 issues today, but before I do that, I will give you a quick backdrop of what it is we do on the Mortgage Committee at the NACTT. It's a committee of over 250 members, both representing trustees, Chapter 13 trustees, as well as mortgage servicers and their counsel. Over the past 10 years, the committee's worked on various initiatives. Probably the 2 most significant are, the first is in 2007, the committee worked on, I think this panel knows about the best practices that were promulgated. And basically they addressed various issues at the time that were going on in the Chapter 13 space. Ultimately, those best practices really was a key driver in the adoption and promulgation of Rule 3002.1, addressing payment change notice requirements, post-petition fee notices, and the notice of final cure requirements. The second major initiative that we've done through the committee was back in 2013, in the final weeks leading up to the effective date of the CFPB monthly billing statements. The committee got together and issued a formalized memo to the Bureau and basically made the comments that the rules that were about to become effective didn't necessarily address the complexities and nuances of bankruptcy law. In fact, we made the points that those rules actually would have led to statements going out to borrowers that potentially were confusing to the borrowers, as well as possibly conflicting with bankruptcy code. So at the final hours, the CFPB issued a bulletin which basically extended the effective date, which now has become April 2018. And I think working with the Bureau, our committee was able to convince the Bureau to get a lot of those points right. And when the rules become effective in April 2018, I think because of the work that we've done through the committee, we'll be in a much better place, as will the borrowers, when they start receiving their statements. So that's the backdrop of what we've done in the past. What are we working on right now? There's 4 main points, like I said, that I wanted to talk about. The first is, and I think is probably the most important, is around loss mitigation. So today, when my clients offer up a loan modification in bankruptcy court, they're unfortunately faced with a big problem, and that is there's a wide variance of expectations across the jurisdictions around how a mortgage servicer is supposed to notify the court and all interested parties of that loss mitigation treatment. In some jurisdictions, a payment change notice is required. In other jurisdictions, an amended proof of claim is required. And in other jurisdictions, a motion to approve a loan modification is required to be filed. And then even in other jurisdictions, a combination of one of those processes is required. To make this issue even more troubling is if you take those variances and requirements across the jurisdictions, we are learning through cases and enforcement actions from the U.S. trustee that failure to comply with those various requirements, it leads to significant reputational risk and legal risk to these organizations if they fail to comply. And so one of the things that the committee's been talking about is that we are concerned that if you think about the fact that a loan modification, a servicer is not required legally, of course, to offer a loan modification, we're worried about what the impact of this liability and the grayness around how to notify the court and interested parties of the loan modification. What is that going to do with respect to the ability of a mortgage servicer to offer loss mitigation in bankruptcy? In other words, if you think back to pre-2008, loss mitigation was almost non-existent in the bankruptcy space. So I remember personally attending the trustees meeting in New Orleans, and I got up on a panel and basically taught the trustees about loss mitigation in that space and what a loan modification was and what a short sale was, because it was new to the trustees. So the point here is we don't want to get back to a situation where mortgage servicers are unwilling to offer loan modifications because the requirements in bankruptcy court are so nuanced, so complex, and draconian. So we are offering up to the Commission over the next several weeks very clear recommendations in terms of amendments to the rules and/or code around this issue. The second issue that we're addressing is what we're calling PCN cleanup. We're finding in the courts that there is quite a few unintended consequences of the Rule 3002.1. Just a quick few examples is there are certain scenarios where it is impossible to comply with the 21-day notice requirement. Probably the best example of this is relates to the SCRA. So when a service member is afforded protection under the SCRA, there are immediate actions that the creditor must take under the Act to essentially adjust the interest rate under a certain threshold. Those adjustments must take effect immediately, and therefore the idea of complying with the 21-day notice requirement is virtually impossible. That's one scenario. There's probably 10 to 15 other scenarios that servicers are facing every day, and they just cannot comply with the rule. The third area I would bring up is the notice of final cure provisions. We on the committee were very excited when those provisions became effective because we like the idea of everyone in the case working under the same accounting of the loan and understanding whether it was past due or not. We have a couple recommendations that we'll be presenting over the coming weeks. I see that I'm out of time. Our last comment really related to post-petition fee notice process, and again, we will be submitting our comments over the next couple of weeks. Our work is pretty much done, and we're excited to share it with you.
Thank you. We appreciate what you've done. There were several of us on this committee that were completely unaware of that work until a couple of days ago. I think Hank Hildebrand knew about it, but he was keeping it a secret to himself. But at any rate, we're so glad to find out about that. It's going to be a very useful tool for us to use as we go forward. Mr. Bonney.
Okay. My name is Mark Bonney. I've been a trustee for about 27 years in one of the smallest population districts in the country, although it's not necessarily the smallest in terms of geographic area. I did submit, made what I thought was a fairly lengthy submission and covered a lot of areas. I'll touch on a few of those. I don't think we necessarily need any debt limits in Chapter 13, but if we're going to have them, 2.5 million, and certainly no, let's get rid of the unsecured, secured dichotomy. I think it just creates too many problems, and it certainly has not been applied uniformly across the country. I think small business cases, individuals in their wholly owned LLCs should be able to file a Chapter 12, and let's just open up Chapter 12 to all sorts of business debtors, including corporations under a certain limit. I think Chapter 12 trustees might welcome that. I think they're probably a little bit better suited than 13 trustees. I'm not saying 13 trustees aren't suited to deal with those, but I think 12 trustees probably are better suited. I think 36 months or potentially more of commitment of disposable income is a fair trade for giving up the right to vote and the absolute priority rule when you're talking about $2 million, $3 million in total debt. And I think if those of you that have followed Chapter 11s and that have less than $5 million in debt, the U.S. trustee has trouble getting unsecured creditors to participate. And quite frankly, and I might get in trouble for this, I think a Chapter 12 trustee would do a much better job of getting a return to unsecured creditors than I've ever seen the United States trustee get. I think there are a number of situations where there's abuses in Chapter 13. Some of that's been discussed. One solution would be to not allow debtors an automatic dismissal or a free right of dismissal. I think if you do have an abusive Chapter 13 and a debtor doesn't propose a plan for a certain period of time, let the trustee file a plan. I definitely support, at least from a modified, and I probably support it up front, why do we even have a planned term? Why do we confine debtors to a set term in order to complete their payments? The fact is some debtors have more hiccups than others, either because of poverty or just because of life events that happen to them. Certainly in a modified plan, we shouldn't have a limit. Maybe in the first time, but in a modified, let's give the debtor 2 extra months, 4 extra months, 6 extra months, whatever it takes for them to get that discharge and complete their plan rather than dismissing or converting. I think from a means test, I was a supporter of the means test, but I think 3-year average income. Creditors look at income as a source of repayment, and if you look at the last 3 years' average income, I think that's a better measure of the debtor's ability to pay, their ability to earn money, than what they did in the last 6 months. Mortgages are definitely a problem. If loan mods are good, then why not let a bankruptcy judge do it? Why are we curing and defaulting, cure the default and maintaining payments on anything? Why don't we just capitalize the arrears from day one and put it in the remaining term of the loan? Why do we have to force a debtor who hasn't made a payment in 3 years on their home mortgage to cure it in 5? I think that makes a lot more sense, whether you give the judge the ability to alter the interest rate or to fix an adjustable rate. Those are more politically problematic, but I don't see it as being politically problematic to just capitalize the arrears from day one and keep the same term and the same interest rate, since we're doing that so frequently with loan mods anyway. Debt, I think I've covered just about everything that I wanted to cover. Student loans, that I totally agree with Deb Miller on that. Student loans, and I put some concrete suggestions in my submission about how to deal with student loans, and I think those are worthy of consideration. Are there any questions that the committee might have of me in my remaining time?
We'll do it as a panel.
Okay.
Thank you, Mr. Bonney. Mr. Jimenez.
Good afternoon, members of the committee. My name is Andrew Jimenez. I am a staff attorney for Alejandro Oliveras, Chapter 13 trustee in the District of Puerto Rico. The last major reform to the bankruptcy code took place in the year 2005 with the enactment of the BAP-CPA. BAP-CPA included enhanced consumer protections. Some of them took form in the regulation of the conduct of debt relief agencies. One of those regulations included that debt relief agencies had to execute a written contract with the debtors, which under the code they are defined as assisted person. They had to execute that written contract, and the contract had to clearly and conspicuously explain the services that would be provided to the debtor and the cost of those services. 12 years after the enactment of BAP-CPA, it appears to me that some attorneys are not complying with this new regulation. And I'll illustrate with an example that is happening in Puerto Rico for the last, that we detected at least for the last 2 years. That is, in Puerto Rico we have a flat fee of $3,000 for services provided in Chapter 13 cases until the confirmation of the plan. That flat fee is established by a local rule, and that local rule is very specific as to what are the services the court expects the attorney to provide to the debtor in order to be entitled to receive the flat fee. Some attorneys, they were filing their cases and they were filing a disclosure of compensation saying that we have agreed to represent the debtor for the $3,000 flat fee, but they included a caveat that if the services that they provided to their clients exceeded the $3,000 fee, they reserved the right to file a fee application. This was happening in a large number of cases. In some cases, we felt that we had a problem of overbilling. But as we were looking more into the problem, we requested copies of the contract. And then we found that the contract did not comply with the requirements of Section 528 because the contract did not specify the services that would be provided in the bankruptcy case, and the contract also was very ambiguous as to what was going to be the cost of the services. The contract specified that they were going to charge a $3,000 flat fee. They cited also the local rule that provided for the flat fee, but also reserved the right to charge by the hour. So the debtor was never informed as to what was going to be the cost of the services. Now, in order to deal with this situation, we've been engaged in litigation for more than a year now. Litigation that consumes a lot of time and a lot of resources. So my concern is that what mechanisms are available so that we can detect these problems early in the case and not have to wait until this is a problem that is happening in many cases before someone takes action. A good instrument for monitoring this situation, I think, is found in the Northern District of Illinois. They have a local rule that requires that attorneys have to file with their disclosure statement a copy of the contract that was executed with the debtor. And I think that is a tool that allows the stakeholders in Chapter 13 to take a look at the contract at a very early stage, and if there is a problem with that contract and an action needs to be taken, you can do it early, or you can just approach that attorney, talk over what are the problems with the contract so that it can be fixed, but not have to wait until it is a problem in numerous cases. And my suggestion would be that the national Rule 2016 be amended to include a provision that, for example, if Section 528 requires a written contract, so anytime that a written contract is required by the code, that the copy of that written contract be included with the disclosure statement that has to be filed under the National Rule 2016. In our district, this is a problem that is not only affecting the debtors whose rights were not preserved under Section 528, but it was also affecting unsecured creditors because some attorneys were charging more than their flat fee. The unsecured creditors were getting less than they would have been entitled to receive if the cost of the services would have been established clearly from the beginning, that it was $3,000 or whatever other amount it was agreed with the debtor.
Thank you, Mr. Jimenez. Questions or comments to the panelists from the committee? Mr. Hildebrand? Oh, Mr. Peake.
I have a question for Debra Miller. Deb, you are a conduit trustee, that's correct?
Yes, I am.
So you're handling the payments
Yes.
on the ongoing mortgage. The problems that you talked about in terms of application of the payments that you send to the mortgage company, are you experiencing those problems with your cases, or is this with non-conduit cases?
I've talked to a couple of different other conduit trustees. They're having the same that I am. So it is an issue that the trustees are aware of. Whether or not the debtors who pay direct are experiencing it, I don't know, because to be honest, I have no direct debtors in my jurisdiction.
Well, are there any steps that you take in terms of when it comes to closing the case to try and ensure the debtor's fresh start? What do you do to try to account for the application of the mortgage payments?
We actually send a QWR request for information to the servicer at the same time or a little bit before we do the notice of final cure. In that QWR, we ask for the unpaid principal balance, the balance of the suspense account, the unapplied funds account, and the escrow account. We then check the UPB against what we believe a properly amortized loan should be. When we get that payoff, we make sure that there's no additional fees or costs or corporate advances that we're concerned about. We then do a motion for determination with the court, setting forth the UPB, the suspense balance, and the next date due on the mortgage. And then we receive an order for the debtor to actually have in their possession, so it's kind of ground zero for both the mortgage servicer and for the debtor.
So in addition to the notice of final cure, you're using an order to ensure the debtor gets a fresh start?
We actually use the motion for determination because our court doesn't believe we can do a motion to deem current.
Thank you.
Does that solve the problem?
No.
So, Mr. Crane, just kind of building on this discussion, when 3002.1 was enacted and the notice of final cure and the response to notice of final cure provisions were put into that rule, the goal was that all parties in interest would leave a Chapter 13 proceeding knowing exactly where they stood, and a debtor would know exactly what they were supposed to pay. I know that this topic has occupied some discussion in the mortgage committee. I know you ran out of time, but since we talked a little bit about what trustees are experiencing, I'd like John to spend just a couple minutes talking about, from a servicer perspective, some of the things that might be able to change here too.
So one of the things the NACTT Mortgage Committee is looking at is the notice of final cure provisions and really the unintended consequences that we've seen as a result of the rule. So I started to say earlier that in 2011, when the rule became effective, I think both the trustees and the servicers were actually very excited about the concept of when a debtor gets out of their or finishes up their bankruptcy plan, really everyone understands what the status of that loan is. Because if you looked at prior litigation, there were so many issues of debtors getting out of bankruptcy only to find out that they had another $5,000 in arrearage that was uncured, and it just threw them back into delinquency, back into bankruptcy, back into foreclosure. And so the idea of the NOFC process just seemed so simple in the rules the way it was written. But unfortunately, in application, we're finding that's not always the case. And I think there's really two issues that really have to be addressed. One, we're finding there are numerous jurisdictions in which the trustees not filing the NOFC. And so the issue never really gets in front of the court to resolve. The second issue that we're seeing is, in addition to the NOFC, we do see trustees filing motions to deem current, in addition, like I said, in addition to the NOFC, and it's just another motion that has to be addressed. And it seems like the NOFC process that was written in 3002.1, that's the way to go, and there shouldn't be anything on top of that.
Any other questions from the committee or comments from the committee?
I guess for Mr. Crane, how do we ensure the final accounting if the trustees' records show that the claims have been paid, that any post-petition fees were accounted for and paid? How does that debtor get an order or something that ensures that they go off with the fresh start after the 4 or 5 years of making the payments?
And I think that's the point that we're trying to make is, isn't that what 3002.1 already does with the notice of final cure, right? So the creditor has the ability to object, and if they object, then it goes to hearing. If they don't, then whatever was in the notice of final cure stands, and it seems like that order stands, right? And if there's a discharge, and the creditor tries to collect on that amount that they didn't object to in the NOFC, I think that's what you can stand on. I don't understand how a motion to deem current would provide the trustee any additional.
Just my comment, there's a difference between a notice and an order from a judge. There's a difference.
Just a comment. So if the trustees are all after an order, if that's what provides the trustees and the debtors with the comfort that they need, then, and this is really what the mortgage committee is looking at, is there a better process that should replace this part of 3002.1? Perhaps a certification process that it is done by a motion that needs to be responded to that results in an order. That would be a single process, perhaps more complicated than what exists today, perhaps not. But it would be one process that we could all agree on that would replace a process that doesn't seem to be that effective right now. So, just a comment.
Any other comments from the committee? From the floor? This is your opportunity.
I had one other real quick. I think the first payment due under the plan should be 45 days, maybe longer. 30 days is too short. We understand the changes to BAP-CEPA that caused that. And gap payments, if we're not going to modify all the mortgages, gap payments should be standardized as those payments that fall due between the date of the petition and the bar date. And that way everybody knows what a gap payment is, and the mortgage servicers can determine what they are when they file the claim.
Yes, sir.
Good afternoon. Thank you for appearing here today. The bulk of my practice now is student loans, both inside and outside of bankruptcy, and I feel for Ms. Miller. A lot of my clients are in the same position as she is. Some of that problem can be dealt with, I think, with talking to the Department of Education about their regulations and procedures for how they handle federal student loans. I'd also encourage you to do whatever can be done to have trustees and judges get used to the idea of what I call fair discrimination in bankruptcy to protect the payment of student loans in Chapter 13. And then finally, an area that is going to require legislation, there's no reason in the world why private student loans should be protected in bankruptcy.
Thank you very much. Anyone else with a comment? Yes, sir.
Steve Wilcox, I represent mostly creditors. Just two things that I think should be rather obvious. One is under 362C3. There are a number of courts which have said that since the stay is only lifted with respect to the debtor, it is not lifted with respect to the property of the estate. I don't think that was the intent of Congress. Clearly, I think that hole should be plugged. Second, with regard to 521A2 and A6, the problem of 30 days versus 45 days for the debtor to act on the statement of intention. Clearly, there's a problem there that we can't, that is, I think, pretty much unreconcilable. There are ways that courts have tried to get around the different deadlines, but I think those were two pretty much glaring holes that were left under BAP-CEPA that really should be plugged. And finally, under 521A7, the hanging paragraph, with regard to surrender of collateral, the stay lifts if the debtor doesn't surrender the collateral, but the stay lifts if the debtor doesn't surrender collateral, but if the debtor does surrender the collateral, then the creditor has to go in and file a motion for relief from the automatic stay to be able to dispose of that collateral. It seems to me that there should be some provision that if the debtor surrenders the collateral, the trustee has a period to object, but then the stay lifts and the creditor should be able to dispose of that collateral. Thank you.
One last comment from the floor.
Very quickly, remember that 362C applies not just in Chapter 13, it also applies in cases where there's a Chapter 13 that's dismissed and a 7 filed within 2 years. So if you're going to say that the automatic stay shouldn't apply to property of the estate, you can repo the vehicle off the Chapter 7 trustee's lot. That is not a result that you want to have. I think you've got to, it's a more complicated area than that because 362C applies to 7 as well as 13.
Thank you very much. Would ask all of the panelists that have participated today, please ensure that your written comments are on the website so that we will definitely have a good record of all of this, as well as anyone else that made a statement today. If you'd like to submit your comments in writing, we'd definitely like to hear them because that's what we're here about, to get your input into this process because we want to reflect in our product what is best for all of you. And we've got a diverse panel up here. We have diverse interests out in the real world, and we're going to look at all sides of it. So please submit your comments, your issues, your concerns, and we definitely will consider them. I want to thank this final panel, and I ask that they be excused. And with that, we are adjourned.